Hello everybody, I'm George from Ireland. So this video, I'm trying to block out the excess of light. It's about criminal law, about the Actus reus. I'm a bit ill, so don't let that put you off. Anyway, so we know that this is the guilty act, Actus reus. But there are certain crimes which are result crimes, and it's only a crime if something bad results from that Actus reus. Most crimes are conduct crimes. It's a crime to commit that action even if no harm results. So dangerous driving is a crime, and then there's, let's say, causing death by dangerous driving, which is only a crime if actually death results. You know, dangerous driving itself doesn't require that any harm arises from that. So result crimes require the illegal behaviour and some injury to arise from that illegal behaviour. So in this case, the prosecution had to prove, for example, in dangerous driving, that the driving wasn't dangerous and there was a death, and that the death occurred as a result of the dangerous driving and not due to something else. So there's a double burden on the prosecution in that case. Then let me see. All right. In case of murder, you've got to prove that the illegal act occurred and death resulted. Likewise, in manslaughter, they have to prove causation. So usually that's a simple thing to do to show that the bad thing, the injury, resulted from the illegal action. There are various principles to look into in this. So let's look into accountability. So we have to be sure that what somebody was doing was of his own free will, and that there's a causal sequence which follows. So it must be a voluntary act. So someone's accountable for an act which he chose to commit, so that the defendant was in physical and mental control of himself. Therefore, it sets off the chain of causation. So he's responsible for what resulted, unless a subsequent event happens, which means that he can't be held accountable, because that wouldn't be fair. It's got to be a major event to mean that the defendant is not accountable for the victim's injury. So usually the defendant is accountable for everything that flows from his illegal act, especially if these are foreseeable consequences. So anyway, the draft Criminal Code Bill of 1989, Clause 17, was about this. So it said, a person caused the result, which is an element of the offence, when he does an act which makes a more than negligible contribution to the occurrence, or he omits to do an act which might prevent the occurrence, and which he is under a duty to do according to law relating to the offence. 2. A person does not cause a result after he does such an act or makes such an omission. An act or event occurs: A, which is the immediate and sufficient cause of the result; B, which he did not foresee; and C, which could not, in the circumstances, reasonably have been foreseen. That's a good summary of the situation in common law. So the defendant is held responsible for a victim's injury if the defendant caused it, even indirectly. So he made a more than trifling contribution towards that outcome. Okay, so this is the court doctrine of causation. So courts sometimes treat things as a voluntary act of a third party, which might breaking the chain of causation. Anyway, even if what happened was sort of foreseeable. For example, D sells a drug to V, V takes the drug, and then V dies as a result. But that was foreseeable, you think, but V's action, that was an act of free choice, taking the drug, and therefore D's not responsible for it. Might see that the law was stupid in that way. So we look at these causal sequences. Causation of the law, 1959. And they say this: an event or an act which makes the difference between something happening and something not happening. Close quotation. That's the factual cause. So it's a factual cause if something wouldn't have happened but for that act. It says the but for test. Well, what's an omission? An omission is a cause of something if the injury would not have occurred but for that omission. Okay, that failure to act. There's a case about this, as in White 2010. What the act that White performed, or an omission, Morby 882, not doing something he was supposed to have done. So White was not responsible for the death of his mother, because he had poisoned a drink. She imbibed it. However, she died of a heart attack. Sorry, she didn't imbibe it. She died of a heart attack before she took it. Okay, so, but what if she'd ingested it but had a heart attack before the poison took effect? Well, then he wouldn't be responsible either. However, if the drinking the poison had caused the heart attack, that would have been different. It would have been a but for. So now, sometimes D doesn't start a process which leads to the injury, but D still contributes and speeds it up. There's a case, Dyson, 1908. A father, he beat up his child very badly, and the boy had to be put into hospital. The child was already suffering from meningitis. Loving father to severely beat his very ill son. The boy died of his injuries. However, medical evidence was evinced to demonstrate the boy would have died of meningitis anyway. So he's charged with manslaughter. However, he was not guilty. Okay. He was guilty because he had sped up the death. That was the argument. Okay. So more things to bear in mind. The causal connection between two things doesn't have to be direct. For instance, 1983, Mitchell. So Mitchell punched a man who said, "You've been queue jumping." And the man who got punched fell on top of an elderly woman who broke her leg, and then she died from a pulmonary embolism arising for that. So, anyway, nevertheless, that the man who threw the punch, he was convicted in relation to the injury suffered by the woman, even though he didn't actually hit her or intend to harm her in any way. This was transferred malice. It made a more than negligible contribution to the harm she suffered. So we look at the legal cause. If what you've done is so insubstantial or remote, then it's not the legal cause. So this is a legal judgment, not a medical judgment. You got to be responsible for the harm that was suffered. So to be legally held responsible for the criminal harm, then your action must have been wrongful as a defendant. Okay. So there was a controversial case, Adams, in 1957, where a doctor he gave his terminally ill patient a lethal dose of painkillers, or heroin to be exact, but that was allowed to be prescribed. So Dr. John Bodkin Adams, he killed his patient with this lethal dose of heroin. But the judge at the time was the great and controversial Devlin. So Devlin ruled, as this was given for palliative care, and that was in consonance with the doctor's responsibilities. It was not the doctor but the malady which actually occasioned the death. So the doctor was not guilty. Now Benge was a little bit different, 1865. So here the defendant was a foreman working on the railways. He didn't bother to check the timetable to see that the labourers were safe to be working on the line. The train came along and killed one of the navvies. The defendant said, "But I'm not responsible because the train driver could have prevented the deaths if he'd sort of pulled the brake on time." However, what the defendant had done was a more than trifling contribution, and therefore he was found guilty of manslaughter. The train driver, on the other hand, was doing what he's supposed to do, which is driving the train at that time. Okay, so there are some problematic cases. So something unusual happens after the defendant's unlawful act. For example, McKechnie, 1992. The defendant beat up an old man, and the victim suffered some very bad head injuries and was unconscious for months. The doctors realised that the victim had a duodenal ulcer, and they thought it was too perilous to perform an operation whilst he was unconscious. Anyway, so then the victim died because his ulcer burst. So D was found guilty, the defendant was found guilty, and the Court of Appeal said that the defendant was the cause of the victim's death because the reason that physicians did not perform the operation was due to the consequences of the beating. So anyway, this is a bit like follows on from Benge. if there was an initial wrongful act of D, can still be the legal cause even if something else happens. Okay, the second cause of the death is only operative as the real legal cause of the death if it's independent of the initial action. Sometimes a death is caused by the victim's mental or physical state, which is particularly debilitated. It could be the interplay between the unlawful act and the defendant's own situation. For instance, Hayward, 1908. The defendant chased the victim. The defendant's wife threatened her with death. They didn't realise the victim had a particularly weak heart and then died of a heart attack. So the defendant was found guilty of this crime. This is the eggshell skull rule. You take your victim as you find him. If you punch someone not knowing it's an eggshell skull and dies as a result, well then it's still your fault for killing the person. You didn't realise this person was very weak and would die very easily from something which wouldn't kill another person. Okay, that's enough from me. Good night.